Good afternoon. Welcome, everyone. Thank you for joining us for the next session of our 2020 Virtual School Law Conference here at Franzik PC. This week, we're excited to talk with you about Shield and Sword, Law as a Driver of Education Equity. I'm Jackie Gadapour-Werns, and I'm joined today by Amy Dickerson, Emily Tulloch, and Jennifer Smith. And I guess I forgot that we have all of our smiling faces on this slide for you. If you need to find us after this webinar or at any time, you can use this information. And we have a very packed agenda for you today, as you can see here from our agenda. Our topics will include school discipline and SROs, racial equity, special education, English language learner issues, residency and homelessness, and threat assessment. But before we get into those specifics, we wanted to start out giving you an overview of what we're going to be discussing today.
Thanks, Jackie. So this topic really came out of brainstorming we did about an article for the American School Board Journal last April that Jackie and I wrote, mostly Jackie, but hopefully I helped a little. So the topic was, how do you use the law as a driver of equity? And what we were thinking about was that, you know, historically, maybe we think of schools as being the wrongdoers involved in a legal dispute. So they're being sued because, you know, Brown versus the Board of Education, because they, you know, were segregating students, or other situations where schools were sued to force equity upon public schools, as opposed to schools being a driver and proactive in supporting equity in their communities. And what we really see from our clients is a desire to be proactive and to use the law affirmatively to support equity in their schools and in their community. So we started to think about specifics around how does that look? What does that look like? What can you do? What does the law provide for as far as a platform or a way for schools to be proactive and use the law for reform? So that's really what we're going to be talking about, all these different topics, but from that perspective of how you can, as a school, use the law, not just wait to be sued and told you have to be equitable or support different populations, but how can you use the law to support, make sure, maybe do some things to support equity.
Great. And I should have said too, as far as a little bit of housekeeping, that if you have questions for us, we hope that you will submit them. We would love to have as many questions as possible. Please use the Q&A function on Zoom in order to submit your questions. It just makes it easier for us to make sure we don't miss them, because sometimes the chat can get a little crowded. So if you could use the Q&A, that would be great. Thank you, everyone.
Great. Thanks, Jackie. So our first topic today that we're going to talk about is school discipline and school resource officers. So let's start out by discussing some of the key equity concerns we historically have seen surrounding discipline and SROs in schools that no doubt have been a focus for your administrative teams, not only recently, but also in the last several years as well. And when it comes to discipline in schools, while we have seen reforms in this area in Illinois and elsewhere through Senate Bill 100 and efforts to move toward more restorative justice practices and less exclusionary discipline, the school to prison pipeline and disparities within discipline practices remain a concern. Exclusionary discipline practices have disproportionately affected Black and Brown students and students with disabilities throughout the country. Nationally, out-of-school suspensions have increased about 10% since 2000, according to some studies, and they have more than doubled since the 1970s. According to OCR data, Black students are 3 times more likely to be suspended or expelled than white students. And other research has found that students who have been suspended are more likely to be held back a grade and drop out of school entirely. Especially for older students, discipline at school, as we've seen, can lead to sometimes students' first contact with the criminal justice system. Especially the importance of focusing on breaking down disparities in discipline remains a concern as a result of all of these issues that are still present. The presence of officers in schools has a profound impact on students of color and those with disabilities, who, according to several analyses and studies, like those that I've shared, are more likely to be harshly punished for misbehavior. Now, over the years, there has been a growing focus on ensuring that school resource officer programs are following best practices. But with a growing national focus on police violence, schools are looking more closely than ever at placement of SROs in schools and potential negative effects on students. So while some schools may be shifting away from having SROs in schools altogether, those who are retaining SROs in schools, we're really seeing focusing on reviewing intergovernmental agreements with local law enforcement to ensure that their SRO programs reflect best practices and that they are supporting a supportive, positive climate in schools. So those agreements should include training requirements for SROs, including training on student mental health needs, identifying and responding appropriately to disability-related behaviors, working with children, and training on trauma-informed practices. It's also important to have agreements that have clearly defined roles and expectations for SROs. So that, and that can be critically important, including making it clear what SROs' roles are in school and how those differ and are distinct from school administrators, especially when it comes to student discipline matters. So because of these concerns, there have been a number of laws passed at the state level over the year that have been focused on increasing equity. Emily, can you tell us a little bit more about some of those?
Sure. So, of course, at this point, SB 100 is not necessarily a new law, but it was really a significant change to school discipline. So as we all know now, it outlines the standards and requirements for school districts when suspending or expelling students and prohibits zero tolerance policies. And in doing so, the focus of SB 100 was really to promote those restorative justice practices and alternate interventions that Amy was just talking about before students are excluded from the classroom, because as Amy said, data really shows that exclusionary discipline can contribute to the school to prison pipeline and some of those issues that Amy mentioned. A little bit more recently, 2 new laws went into effect over the last year that relate to school resource officers as well. The first is a law that focuses on questioning by law enforcement officers or school resource officers on school grounds. And that's where school districts are required to notify or attempt to notify a student's parent before detaining or questioning the minor on school grounds. And then if a parent can't be present, certain school personnel must be present for the questioning to safeguard student mental health, make sure the questioning is in line with questions that are appropriate to be asked for minors, those types of things. And then the other is legislation that requires SROs to complete training developed by the state, which requires law enforcement agencies that provide school resource officers to schools to certify that the officer has completed the required training course within 1 year of assignment or has prior experience that satisfies that training requirement. And law enforcement agencies have to begin providing these certifications or waivers if they're applicable at the beginning of next year, so January 1st, 2021. So that's going to be something to watch out for and make sure you're in compliance with.
Thanks, Emily. Jennifer, can you talk a little bit about what happens to a school or district if concerns are raised that its SRO program or discipline practices are inequitable?
Sure. When you say concerns, I immediately think, there's the call to principal or talk to the school board concern, but then really what it escalates to is usually an officer of civil rights complaint. So we've seen those over the years, that if there's a concern that rises to a level of where a community member thinks the SRO's role is discriminatory against students of color usually, that they would file an OCR complaint. We've seen a change over time in how those were addressed by OCR. Before this administration, there were complaints that would be then viewed as systemic, and you as a district would be asked to provide the federal office with your data for interactions with school resource officers, and particularly if school resource officers play a role at all in your discipline process. That's really where things become entangled, and you can't just say, well, that's a police matter, that has nothing to do with us as a school district. So if resource officers are making judgments about when a student should be disciplined, as opposed to not just making detention and criminal determinations, but actually part of the process to decide what happens in the school, then we're off to the races as far as OCR looking at whether they're discriminatory. More recently, I would say OCR has taken a more individual approach, and they'll dig deep into the specific incident of, so if a parent complains about their own child, that scenario, and looking at, what happened in that scenario, including all the records, all the videos, that kind of thing. So that's really the process. And then OCR would reach a conclusion about whether or not there was discrimination based on either if they did a systemic review or an individual scenario review.
And can you talk a little bit about the new Jewel litigation and that overlap with school discipline issues?
Sure. There's a number of legal actions being filed by school districts and some different venues seeking resources, seeking damages really from Jewel, to have Jewel pay schools because of all the school resources that are taken to address the discipline that's required by the use of Jewel products and so e-cigarettes in schools. So overwhelmingly, I think our high school clients are seeing, it seems like when everyone was in school, most discipline scenarios involved in some form or fashion an e-cigarette or there was a drug component, and it's usually that now. We're not seeing that's just predominant in schools as far as drug misconduct. And so this litigation is seeking funds from Jewel for all the resources it takes for schools to address that conduct in school, which is really taking time of administrators and attention away from other initiatives. So it's an interesting, again, going to that idea of being proactive instead of reactive. So instead of just having our resources drained, we see this kind of plague on our students and feeling helpless to that, and just accepting that it's diverting resources. Some schools are affirmatively seeking, no, Jewel, you need to pay us, and we need additional resources to address the scourge that you've released on our district, basically. So again, it kind of fits in with the being proactive and going out to seek resources and supports for students, not just waiting to have it happen to us.
Well, so speaking of proactive steps, now that we know that many schools and districts are interested in going above and beyond the minimum of what is required by the law, so for each topic that we are going to be talking about today, we will address some key takeaways that focus on what steps schools can take to proactively address the issues we're discussing. So for our issue surrounding discipline and SROs, let's discuss steps that schools can proactively take to address equity issues in schools as it relates to discipline and SROs. And a lot of those really are what we've sort of highlighted already as we've been talking about this issue. So as we've just discussed, you will want to make sure that your SROs complete the state required training that Emily talked about, plus any additional training requirements that you decide to impose, either because they're already factored into your intergovernmental agreements or that you are considering requiring of SROs now. And if you haven't recently done so, we strongly recommend that you review your district's intergovernmental agreements and incorporate best practices for your SRO programs, including training and including clear job responsibilities and expectations. This is something that we often will assist districts with, so we're happy to assist you with that as well. Districts should also review their policies and procedures to ensure compliance with state and federal laws, including any policies regarding questioning of students, to ensure that they're incorporating the new laws that Emily went through. For example, we know that some intergovernmental agreements even have exhibits that reference expectations for questioning by school resource officers, and some policies reference this as well. So it's important to look at those, if you have those in place, to make sure that they're updated. Jackie, do you want to talk about some other steps that districts can take as well?
Yeah, so as Jennifer mentioned, my old employer, OCR, they will come knocking on your door if you do something wrong when it comes to SROs and discipline and equity. But you don't have to wait for OCR to come your way in order to make changes if you want to be proactive. And actually, OCR's materials that you can find actually on the internet, available to the public, in the form of resolution agreements that they've entered into, particularly under the old standards that Jennifer was talking about, where they would often look, get one complaint about one disciplinary incident, and they would look at the entire school district to see if there were issues with discriminatory discipline. And so you can look to those agreements to get a lot of really good examples of the types of things that you can do to proactively address either any concerns that may exist, or even to prevent concerns that don't yet exist in your school or district. So we refer to this idea of looking under your own hood as an audit. And we put that in quotes throughout, because it's obviously not an audit in a formal sense. It's more just taking a look at your own policies, your own practices, your data, to see if you have any disparities in the way that you treat either minorities, racial minorities, students with disabilities, or any other particular subgroups. And then you can use the ideas that can often come from these OCR agreements, things like having a committee with students on it to meet once a month to talk about how discipline is imposed and how SROs act within your school district, to get their ideas. Other ideas are identifying a discipline supervisor, someone whose job within your district or school is to think about how discipline is imposed and whether it is imposed equitably. And then more generally, just looking at data to see if you have any issues with disparity in implementation. And then, as I said, if there are issues, there are lots of ways to address them. And that, again, is something, it's certainly a lot, I think, more beneficial. I find it more fulfilling, certainly, to be helping districts from this side of the table with addressing these things proactively than it was having to come in and find errors and mistakes, even inadvertent ones, by districts when I was at OCR. All right, so our next topic is racial equity. And Emily, last week during our First Amendment School Law Conference training, we had a lot of questions about how schools can use their curriculum and their leadership roles in the community to further racial equity platforms. So we know that there is some movement on the legislative front, such as the Legislative Black Caucus's fall legislative agenda, which is focused on equity in education. And there's a lot of other pending legislation addressing changes in things like history curriculum, to address contributions of African Americans to our history, and requirements on using specific books, and specifically diverse books, in our schools. And we also know that many schools and districts are hungry for change in the area of racial equity. especially with the long, painful history of the treatment of racial minorities in our country, and particularly with individuals who identify as BIPOC, which stands for Black, Indigenous, and People of Color in this country by the police and other systems. And that issue really culminated this spring and summer with the murders of Breonna Taylor and George Floyd, and brought this long-standing issue to the forefront of our consciousnesses. So, Emily, what can schools do if they don't want to wait for these types of changes to come from the legislature?
Yeah, so there's several ways that districts can really address issues of racial equity without waiting for requirements from the legislature. And one way is that your school board could make a statement supporting, for example, the Black Lives Matter movement on behalf of the district. Courts have really repeatedly held that school boards have a broad discretion to create and determine educational policy on behalf of their districts, and that schools really play this really very important role in preparing students as citizens and instilling fundamental values in them. I know I'm kind of preaching to the choir right now because you all do this important work every day, but this broad recognition of authority on this issue is what would make a board statement addressing school climate and culture as it relates to racial equity appropriate. And we do recommend that this type of support statement comes from the board as a whole, and not individual board members or administrators or other employees. If your district or school wants to consider making this type of statement, we recommend reaching out to us just to make sure that it's done in the most appropriate and effective way. And as Jackie mentioned too, another way is that schools can implement certain curriculum changes to highlight African American history or to incorporate conversations about equity into the classroom. So for example, some school districts across the country have incorporated the 1619 Project into their history curriculum. And for those of you who may not be as big of a podcast geek as I am, the 1619 Project is an ongoing initiative from the New York Times that really aims to reframe US history by placing the consequences of slavery and the contributions of Black Americans at the center of our cultural narrative. So those are some of the ways that schools can be a little bit more proactive in this area in terms of incorporating these ideas into their school climate and culture.
Yeah, thank you, Emily. And I think that the key here, as Emily mentioned, is that like with the board statement, we want to see these curriculum choices coming after thought by the school or district about what issues should be addressed in the curriculum and from what angles. So if any of you watched our First Amendment School Law Conference session last week, you know that we talked about the more limited First Amendment protections that teachers have when they're teaching in the classroom. So it's important that your school or district think through these questions at a team or building level, or even at the district level. That's going to provide support and protection for your staff when they're teaching these issues because of that broader protection that you have. I do see we have a question. Do local school councils have equivalent broad discretion? I want to give a shout out. I'm on a couple of LSCs, and so I love that we've got some LSC members. For those of you who don't know, LSCs are sort of the mini school boards that each school in the city of Chicago has. They do have more limited roles and responsibilities, so you are going to want to make sure that whatever you're doing is going to be in line with the district's what the district is mandating, because obviously we as LSC members and LSCs have, we just don't have the same broad rights and discretion and responsibilities as school boards. But I do think, generally speaking, as long as it's within the confines of what the district has said, that individual schools, individual LSCs, they can be thinking about and doing these things as well. So now that we've discussed how schools can use things like board statements and curriculum to support racial equity, let's talk about some other ways. So Amy, what are some additional ways schools can maintain or support racial equity?
Yeah, so certainly looking at the different aspects of public education that we're covering today and considering some of those takeaways we're offering are obviously steps schools can take. More broadly, some things to consider. The Illinois Association of School Boards has actually put out a great article on 10 ways that school boards can champion racial equity that offer suggested approaches to consider, including developing goals and policies with a strong equity lens and identifying and removing policies that support disparities. Including those approaches also recommend, looking at the fiscal angle of school districts, in particular districts, and their board budgets, and changing the school budget options to prevent disparities where those might be identified. They talk about the importance of boards being data informed and developing partnerships and allies to achieve equity, including outside organizations, as well as considering comprehensive approaches that can incorporate various aspects of school districts programming, including programs to incorporate trauma responsive schools like Partnership for Resilience or the Center for Childhood Resilience. In addition, districts can really look at their training and professional development that they're offering, not only on required trainings like implicit bias training, but also incorporating practices more broadly as well in the classroom to promote equity, from best practices for incorporating equitable instructional strategies, such as to facilitate classroom discussion and best practices around that, to ensuring that staff are trained on the best ways to support students that are high mobility students that are coming in, transferring from other schools, and ensuring that there's access to immediate information that parents and students may need for the school and quick transfer of records to help ease some of those transition services. So with that, I don't know, Jen, if you want to talk through some of the takeaways here.
Yeah, I mean, I think you each hit on a different component of these. So takeaways, if I were to summarize what you just said, first of all, mission statements. Boards can give global statements. They're authorized as a board, as an entity, to make their own policy determinations, including their broad, embrace of equity statements. And just to reemphasize what Jackie said, so at the school level, it would be affirming the board statement, not, and so you could affirm a board statement and be within the board statement, but no individual actor, you're just reaffirming the entity's position on equity. 2 would be an implementation of non-discrimination policies. So everyone has those on the books, looking at how you're living those, looking at how you're doing that either through your data or other initiatives to make sure it's not just in policy, but in practice. And then curriculum supporting equity education. I think you've mentioned a couple different ways that can be done and should be done, and is certainly, again, curriculum is something that the board has control over. It's not an individual actor speaking on this. It's as an entity, this is our position. That's where you have the strongest legal position to make statements and make decisions about what is taught to students in our schools. Is through the curriculum.
Yeah, and that goes in line with, we received a question of, what about teacher training in cultural diversity and sensitivity training? Many teachers do not have the same experiences of a certain population of their students. They don't have an understanding of their culture. Can we speak on that? And I guess my initial thought, and then I'd be curious to know what the others here have to say, but my initial thought is that it's similar to what Jennifer's talking about. I absolutely think that it's an appropriate thing for a board or a school to implement, as long as it's, again, we like to see these things coming from a very well thought out, broad-based decision, as opposed to a one-off by a particular teacher or one-off by a particular, department chair. I don't know, Jennifer and Emily and Amy, if you have thoughts on that.
Yeah, no, we put student or teachers, I think we make them vulnerable if we start leaving it to individual teachers to integrate certain concepts into the way they teach. And I say that because if they're not teaching the district's curriculum, you know, then there's action that can be taken. And when complaints are made, there's nowhere to back them up, so to speak. So so before having teachers feel like they need to go rogue on this or something, or they want to go rogue on this, I think it is something where it's better to be, and it's really necessary for it to be a district decision. This is what we teach our students in this district. And because that, again, that's where you have legal authority to make decisions, not on an individual level, but on a systemic level.
And I think we see support in the school code for that kind of training as well.
So then next, we're turning to special education and looking at ways that it can be a driver of equity. So built straight into the laws are concepts that require a thoughtfulness about equity concerns. So when you're evaluating students to see whether they're eligible or not, the assessments that you use, the evaluation tools, must be non-discriminatory. So there must be a thoughtfulness about our selection of evaluation in our process to make sure that we're not embedding just in the very process some sort of screening tool that either is going to over-identify or under-identify populations. There's also requirements as far as disproportionality, looking at, again, under-identification, over-identification, and eligibility, discipline, and residential placements. Those are all three areas that the special education law require attention to disproportionality and equity. And then, you know, from my personal experience, I would say considering the distribution of resources in this area. So often, you know, a lot of services, attention, individualization goes to the squeaky wheel, and the squeaky wheel is often the parent who can afford an attorney in this area. So just thinking about how we're designing and how we're making decisions about where our resources go for students with disabilities, that you know, to sort of resist some of that built-in structure where yes, there's dispute processes, but of course that advantages those who are sophisticated enough to access those. So thinking of ways to not make that a barrier to parents actually getting and students getting resources. So Amy, in thinking about this topic, RTI, it was one reform put into place. What are your thoughts about RTI and how that drives equity around special education?
Yeah, so RTI was intended to address disproportionality and eligibility and overclassifications of students with learning disabilities. And in 2004, IDA strongly promoted RTI as a multi-tiered approach to provide support for students with learning and behavior needs in response to a growing number of students being overclassified as having learning disabilities. So as a result, many districts have adopted RTI as a multi-tiered approach, and different research studies have identified RTI as being a likely factor in having fewer students being classified for special education services. But educators do still largely recognize that in order to have a successful RTI program, fidelity of RTI implementation and data are key components to that success, and having high quality research-based instruction and ongoing student assessments are also critical to that success. And you know, we did see renewed focus on special education equity through multi-tiered approaches like RTI and the Every Student Succeeds Act, which also promoted the use of federal funds on things like developing programs and activities to increase teachers' ability to effectively teach children with disabilities. So what we've seen is that those looking and studying RTI models still stress the importance of districts engaging in ongoing review and discussion over their programs to identify and address potential inequities within their local systems. So districts who are, districts that they're instituting periodic reviews of how they're implementing and utilizing RTI, that can be critically important to the effect that it can have on driving equity. Also, having consistent attention to staff development in teaching students within a wide range of learning needs can also be critically important. And others who have also studied RTI programs also highlight the importance of educators implementing RTI through a culturally responsive lens in order to best meet the needs of all students.
So Jackie, what about what did you learn from your experience at OCR on how OCR addresses equity in special education?
Unmute. I'll tell you first of all that I do have here on this next slide what I often think people find maybe surprising about OCR's work, which is that you know, disability discrimination complaints are by far the most common at OCR. So you can see here that over half of the complaints that were received for fiscal year 2019 were in blue here were the disability-based complaints. And what's interesting is that a lot of the complaints are really back to basics. And so I think sometimes we're thinking about all of these amazing issues that Jennifer and Amy have been talking about, and a lot of them are pretty high level. And but what we often saw when I was at OCR was a breakdown at the more basic level, like making sure that teachers are familiar with what the expectations are for doing things like implementing modifications and accommodations, or you know, making sure that there's adequate communication between the family and the student. And so, you know, I do think that we have to keep all of that kind of in mind as we're figuring out what direction to go in with disability and equity.
Great. So just to summarize the takeaways from the special education section. So first, you know, internally look at your access to special education supports, whether that's making sure the tools you're using, the processes you're using to identify needs are non-discriminatory, making sure that your RTI process is robust and up and going. You know, there's, I think, still a lot of development around implementing RTI that is still underway. Looking at your equitable use of resources and ways to maybe making decisions, strategic decisions about when you're going to fight something, when you're not, thinking, having one lens you use as how, you know, is this decision, how does it impact equity as far as how we're using resources? And then third, some things we haven't really spoke about yet, but remote learning is definitely throwing, you know, the table up in a lot of ways. And, you know, it's pretty complicated as far as, you know, there is a guidance from ISB that special education students should have a priority for in-person learning, but we also know that there's a lot of challenges. And then, you know, the basic concept of special education, which is least restrictive environment. If we're isolating students, if we only prioritize special education students, that means they're isolated again. And that's obviously sort of counterintuitive. So a lot of complicated factors as far as remote learning and equity, but another factor to be thinking about as you're doing your planning.
Okay, so our next topic is English language learners or English learners. These are students who their home language background is a language other than English, and their proficiency in speaking, reading, or understanding English is not yet sufficient to provide the student with the ability to do things like meet assessment goals or achieve in the classroom taught in English, or just otherwise to participate in the school setting as fully as their peers. So both state and federal law require that schools provide equitable education opportunities to students for whom English is not a first language. Emily, can you tell us about the legal basics when it comes to English language learners?
Yeah, so on the federal level, Title VI of the Civil Rights Act prohibits discrimination based on race, color, and national origin. And Title VI is enforced by OCR, and some of the most common topics addressed in complaints under Title VI with respect to ELL students include concerns about, the quality and appropriateness of programs used to educate those students, potential segregation concerns because ELL students may be educated apart from their non-ELL peers, and concerns about effective communications with parents who may have limited English proficiency. Outside of Title VI, there are some other federal laws that allow for lawsuits against schools that fail to provide equal educational opportunities to ELL students. In the interest of time, we won't get into those today. And there are also parallel laws that require equal education, that prevent segregation and provide a lot more specificity with respect to what ELL programs must look like at the state level as well.
Right, it's hard to believe that Emily and I met years ago when I was working at OCR as an attorney and she was there as an intern. But that's another area that OCR covers, works on. And there is actually a key document that we wanted to recommend and highlight for you all that you can familiarize yourself with when you're trying to understand, what you can do if you're aiming to proactively ameliorate or increase the benefits to English language learners in your school or districts. And that's a 2015 guidance document from the Department of Education's Office for Civil Rights from OCR regarding EL learners. I think it's actually not rescinded, ladies. Am I correct on that? It's one of the few that has, you may know that the Department of Education OCR has rescinded a lot of guidance from the Obama era, but that is one document that I think is still alive and kicking. And if you're not already familiar with it, it provides guidance on common civil rights issues facing English language learners and includes examples on best practices. And so as far as kind of summarizing what some of that looks like and also some recommendations that we have for you, so first of all, you see here again this language of an audit where we're suggesting that rather than waiting until someone has filed a complaint, that you take a look at your own practices, including your identification practices. And that would be particularly not just for identification of students as EL students, but also, are you identifying EL students more frequently for special education? Is there less access to extracurricular activities? Looking at things like that can help you not only to identify and assess every EL student within the district as is required, but also to help make sure that those students are accessing all facets of the education that you're offering. And one thing to keep in mind here is that you can look at things. I've actually got this as the second bullet here, that to consider impacts on and needs of small language groups. And that really goes hand in hand with the third bullet point, which is that a lot of times program standards for ELL, they are a floor. They're not a ceiling. And so, I've seen a number of districts that we work with doing really great things that go above and beyond what the minimum standards are under Illinois law for what you must provide EL students. And so, for example, paying attention to small language groups, which sometimes can get left out of the legal requirements because, fairly, I think a lot of the legal requirements, they'd only make you do things if you have a significant number of students or parents who speak a particular language. But if you're looking for a proactive way to increase equity, looking at small language groups, looking at services above and beyond what is required can be really great ways to do that. And I did notice when I was at OCR that that most frequent EL complaints that we received actually related to parent communication. So that is a place where, looking at how accessible is our website to parents who are, don't speak English as a first language, and where could we go above and beyond for some of our populations in order to provide more communication, whether it be through newsletters or websites or anything along those lines. Another area when it comes to parent communications that often is a sticky one relates to translators and interpreters. And, you know, the rules are frequently changing on what is allowed with respect to translators and interpreters. So that would be a place, if you're looking to audit your programs and find a place where you could improve things even without a complaint, I would recommend that that would be a great place to start. And as with all of these things, always feel free to reach out to us if you would like help or additional guidance with how to do those types of informal audits.
So switching gears a little bit, getting into residency and homelessness now. So one of the concerns in terms of equity in residency matters really relates to the fact that student enrollment is so dependent on the residence of a student's parent or guardian. And this matters because of the continued inequity in school funding systems that has led to a growing number of students who are from lower income families attending school districts where poverty is concentrated. So just by way of background, in most major US cities, and that includes Chicago, a majority of students of color attend public schools where at least 75% are from low income families. And if you look at just Chicago, that jumps to over 95%. So these schools are really essentially being segregated by both race and class. And these types of structural equity concerns lead to many of the residency issues that you all see when you're enrolling students. What are some ways that school policies or practices regarding residency can be modified for more equitable results? Jennifer, do you have any thoughts?
Sure. Well, one area is facilitating clear communication and assistance to families who might reside in non-traditional family units. So when it's not when families are living with extended family, sometimes that and the homeowner or the person on the lease is not the parent or guardian, that can create barriers or additional paperwork at a minimum for families in order to get through the registration process. So just making sure your frontline employees are well trained and back to Jackie's point, also have access to translator services when they're needed to help facilitate and get those families through the paperwork where they are proper. They do qualify as residents, but it's not always, on Form A, so to speak. So helping them through that process.
And what can schools do kind of in terms of those required enrollment documentation pieces so that families, in transition or homeless families or families that have maybe non-traditional family structures can have equitable access to their education? Jackie, do you have any thoughts?
Yeah, so I would say one thing that I find myself when I'm on the phone, and I'm often on the phone with school administrators or staff who are in the trenches, they're trying to help get students enrolled, and they're coming across barriers where they're finding that they have a list of forms that they request that parents and guardians complete that usually includes documentation that parents or guardians are required to provide. One thing that I always try to remind people of is that you are not allowed to request, to request specific documents, to require that you must provide me, for instance, a driver's license in order to prove your identity. There is a lot of room and, in fact, requirements to offer flexibility, which can help individuals who are in a number of different unique situations. But particularly can come into play when you're dealing with students who are coming here from another country and their parents may not have with them all of the documents. They may not even be with a parent. And so they very well might not have the documents. And then you may also have situations where people are doubling up if based on their financial situation, based on the need to move from a different country, for various reasons. People may choose to stay with someone else in your district, and so they might not have things like a lease or a mortgage document or the types of things that you're used to asking for proof of residency. And I always, when I'm on the phone with people who have these kinds of questions, I always start out with the question of, do you have a concern that this family doesn't live in your district? Because if you have that concern, we absolutely should do our due diligence. In fact, you are required to do that due diligence by law. You're not allowed to just open up your doors and let anybody in. They have to meet the residency requirements. However, if you don't have a concern that someone is a non-resident, then you have a lot of flexibility in working with them on making sure that you can get the documents you need. And remember that when it comes to birth certificates, we even have flexibility there as well. Where we want to have our red flags and be concerned is if someone we don't think that they are actually the parent. We think that this child is maybe in a situation that's unsafe. That's where, that the law requires contacting law enforcement. It's meant as a protection for students. But if you're not concerned about that, if you feel like you have valid evidence, then call us and we can work with you to, work with ISB and make sure that you're complying with the law while also not creating unnecessary barriers for families that may be facing challenges.
Moving to our takeaways, Amy, could you describe some of the ways that districts can be proactive in identifying and addressing equity issues that relate to residency and homelessness?
Yeah, I think considering a lot of the things that everyone's already talked about, with those things in mind, you've heard us say it before in other areas, but this is another area where districts can and should consider conducting an internal, audit, so to speak, of your residency policies and outcomes. Look back at the residency investigations that you have initiated over the years. And if those have only been families of color, or a disproportionate number have been students of color, that's a red flag to look at, is there an equity issue that we have, whether it's in our policies or not necessarily in policies, but in our practices, and then go from there in terms of addressing, where are the steps forward. Review your enrollment documentation and consider the things that Jackie talked about in terms of, what does it say on paper that's required, and are those outdated, and do we need to update those? And then making sure that your frontline staff are trained on how to use those forms if they are updated, to make sure that in practice you also are seeing that flexibility that Jackie talked about. In addition, we want to make sure that frontline staff, who often may be the ones bringing to your attention evidence of a potential concern that someone might not be living in the district, what is that evidence? And is that based on objective criteria or subjective information? And if more times than not, it might be based on, subjective information, that's another area to look at to really see if a deeper dive in training and your policies and practices, it really should be looked at. And I think another area for training as well that shouldn't be overlooked is with your homeless liaisons, and making sure that is not just a title that's tacked on to someone's position, but that those individuals are really trained and are brought in not just when there is a question about someone's eligibility as a homeless student, but also making sure that they're really providing all of that support that the law does anticipate and in many places require the districts provide for our homeless students. So with that, we're going to turn to the last topic that we're going to be talking about today, which is threat assessments. And in light of the significant number of shootings and school violence throughout the country, the School Safety Drill Act in Illinois was amended last year to require that all Illinois school districts implement a threat assessment procedure, including the development of a threat assessment team that includes specific district and school level personnel, as well as a law enforcement official. So there are various equity concerns that have been raised in various venues throughout the country regarding the effects of conducting threat assessments in schools, particularly concerns that student threat assessments and or removals, if not conducted appropriately, could disproportionately negatively impact students of color as well as students with disabilities. And this risk especially seems to be heightened where teams are reviewing to assess threats without using a clear, uniform methodology to do so, or if they're not utilizing supportive interventions and restorative practices to help with early identification of students who may need additional supports. This risk also seems higher if teams are not considering the necessary context of students' behavior, or if they don't have the information that they need regarding the background or history of students. And Jennifer, is there a particular risk for students with disabilities being negatively impacted through the threat assessment process if not done appropriately?
Absolutely. So this is known as far as looking at factors that are going to flag students. And so it's important if teams flag certain behaviors as being those that in a general ed population, a teacher is going to flag as threatening, that those behaviors need to be supported. So it's not escalated into a risk assessment, but handled and supported through the IEP process and through maybe a gen ed, maybe it's one of those situations where a gen ed placement's not appropriate because those behaviors do need a higher level of support. And really is where I've seen the disconnect at times, is where a student is being stepped down from a more restrictive placement to a less restrictive placement, and behaviors that are known to be non-threatening by those expert with the child's needs, when they're viewed by an outsider without any support, might get a trigger of this is a potential school shooter and send all the way up the flagpole, so to speak, and really cause a problem for the student and it's inaccurate too. I guess the point there is that if we know the student is not a threat, not where it actually is an indicator of a threat. So that's where I would say we have to be extremely careful and thoughtful about supports so that does not happen.
So Illinois school districts are required to have threat assessment procedures. So Jackie, do you have thoughts on the best ways that districts can best protect themselves against inequitable results when carrying this out?
Yeah, so I think the best way to avoid the inequities, as Jennifer mentioned, with respect to students with disabilities, we also often will see those inequities with students of minority racial backgrounds. And so the way to really address that and to avoid it is to use an established methodology and to apply it with fidelity. So we really do recommend that each of you identify and adopt a research-based threat assessment protocol to be used by threat assessment teams when evaluating individual threats or indicators of risk of targeted violence. And remember that you may need to think outside of just traditional threat assessment when you're thinking about this. I think a lot about Title IX, along with these other two ladies who are up here, and there is now a requirement under Title IX that if you can remove a student who is determined to be an immediate threat to the health or physical health or safety of others in the community. And we have the same concerns about, making sure that you're using some sort of established methodology, or at least some sort of protocol that is very objective and not subjective. And we are big fans here at Franzik of the comprehensive school threat assessment guidelines that were developed by Dr. Dewey Cornell from my alma mater, the University of Virginia, Wahoo Wah. So that is one example, but it is certainly not the only example. But the methodology should really focus on prevention and appropriate identification. And then obviously you also have to train on whatever methodology you choose.
Yeah, and we've actually, when this requirement in the state law was put into place, we did offer for districts and still offer for districts a model threat assessment procedure that, despite the law itself being quite brief, we have recommended a number of different approaches. And one of those is to have your team meeting on a monthly basis to do a number of things, including, going through the methodology that you're using, practice application of different scenarios, scenarios, monitor and review cases, but also that's a great opportunity to then review your practices and protocols for potential inequitable trends, and to be able to identify, places where you may be more vulnerable and having inequitable results, and what you can do to overcome those, as well as to incorporate training for your threat assessment team members, not just on the methodology that's being used, but also on the issues that we've been talking about, and in making sure that the threat assessment team members are really being able to be trained on, any implicit racial bias training that would benefit them when they're going through these threat assessment processes, as well as thinking about what training is needed for your whole teaching staff, as they are often the frontline ones that are bringing potential concerns to threat assessment teams. In addition, one thing to note too is considering the confidentiality of records. As I noted earlier, the School Safety Drill Act does require that threat assessment teams include a law enforcement official on the teams. And keep in mind that those law enforcement officials can be, information can be shared with them under FERPA and ISRA if they are considered a school official. But it's a best practice to actually incorporate into your intergovernmental agreements a clear indication and agreement that the law enforcement official that will be serving on a threat assessment team, is considered a school official for that purpose and falls within that exception. But what's important to note there is that when falling under that exception, that information can be shared with that threat assessment team member, but information by that member cannot be redisclosed to others, including to employees of a law enforcement unit. And having that really spelled out can also really protect students in this process, and ensure that on the one hand, information is shared where it's necessary, but that information is not overshared that can negatively impact the students.
So with that, I know we're a couple minutes over. We do have a couple of comments and questions that I'm going to address, but we'll try to move through them quickly. So one was a question from one of our favorite webinar attendees. So how does President Trump's recent executive order regarding doing business with agencies that do diversity training affect school districts that are working hard to recognize and serve all their students and the community? And the short answer is you don't really need to change anything right now. If you want to find out more about the executive order, you can find on our thought leadership page at franzic.com. We did do an alert on this, and our general takeaway to you is you don't need to change anything right now. That was an executive order that came out a few weeks ago from the White House that purports to limit the use of certain types of diversity training by contractors, federal agencies, and also certain grant recipients. Right now, the biggest sort of impact that could have on schools is with respect to those who are grant recipients. But we don't really have any reason right now to think that you need to change any of your practices, because there is going to need to be further clarification from the Department of Education, maybe further clarification from the courts before we are going to be suggesting that you make changes. So thank you for that question. We did have a comment too, and I'd be interested to hear from our other panelists if they have thoughts on this, but the comment was, many districts are hiring an administrator with the title of equity and innovation or something of the like. As a former teacher, I see that many of the issues are with the teacher, with the lack of knowledge of how to interact with students of color. It seems that the district is looking for one administrator to implement the magic solution to the issues that many districts face. I strongly believe that many issues will be resolved at the teacher-student relationship and understanding. I think that's a great comment, and I certainly don't think that there is any magic solution to any of this. Amy and Emily, I don't know if you have any thoughts on that comment as a closing.
Yeah, I agree, and I think that you can have the best policies and goals in mind, but if there isn't both full appreciation throughout the schools and district and the appropriate training and supports and tools for those who are really the ones that are going to be implementing a lot of these efforts and policies, then you're not going to see the results that you need.
All right, well, thank you everyone. Thanks for sticking with us through the end here. We're always grateful to have you with us. Please also join us next week. We are going to be having a very exciting session on bargaining in the time of COVID 2020 and beyond from our amazing labor bargaining team here at Franzik. And so we hope you'll join us to find out everything that you ever wanted to know about the changes to bargaining that have come in this wild roller coaster of a year. In the meantime, please take care, and we'll look forward to seeing you again soon. Bye, everyone.